one.
Okay, good morning, everyone. As I was thinking about this, this is the first in many ways. It's the first meeting in 2022. It's the first meeting that I act as chair of the ADRC, and it's the first meeting of three new commissioners, Linda Seeley, John Taylor, and Mark Harwell. And so as a result, then welcome to the new commissioners. And so we have an order of business, and that is the first. We met last on October 14th of 2021. It's attached as exhibit number 2. Those are the minutes from that meeting. Are there any corrections to those minutes? Not hearing any corrections to those minutes, do I have a motion and a second to approve the minutes as presented in attachment number 2?
Motioned.
Second.
All right, we have a motion and a second. Then all those in favor say aye.
Aye.
Any opposed? Okay, the minutes are approved as presented. The second thing that you have in attachment number 3 are statistics for Rule 31. And you have those statistics there in attachment number 3. And also I asked staff to send out another attachment number 19 that is a summary of the statistics year by year. I want to spend a moment talking about those statistics because I'm going to be working with the staff, talking in more detail about them. Here's what I gleaned from it, is that in 2018, we had 6,357. And I understand there's underreporting. I understand we may not capture everything. I understand that we have a lot of work to do in terms of really developing these statistics. But based upon this particularly, there's one statistic that I found very, very interesting. But in 2018, 6,357, 2019, 6,824, 2020, 6,618, 2021, a significant jump, 7,150. And I want to link back to something that Director Tate said about how we jumped on this, the pandemic and the backlog and all of that. Let me tell you, Justice Lee, thank you. It was you who, in fact, led this charge. You're the one that initiated this. We, in fact, grabbed a hold of it, but obviously, you're the one person I know that has a great deal to have done with this. And so we appreciate it. In addition, as I will tell you later on, one of the initiatives is Justice Lee contacted me back in September or October and said, I want to revise the plan. And I thought, well, why would she want to revise the plan? And of course, then I realized she said, I want to remove the pandemic. What we want to do is that we want to encourage then referrals to mediation without regard to whether or not there's a pandemic or not. It was a great move. Thank you, Justice Lee. Here's the statistic that I found very interesting. And I went back and looked at all of the numbers, and I'm going to do a report to you. But if you remember when the pandemic hit, there was a hue and cry that the sky is going to fall in, that we can't do this by Zoom. We can't do this online. The settlement, in fact, one of the skies going to fall in was the settlement rates will drop precipitously. Here are the statistics, is that 18, 19, and 20, surprisingly enough, about 1.3% of the mediations were done online. 2021, at the end of the year, including phone conferences, almost 30% were done, okay? And I'll give you the backup documents that were there, almost 30%. So the next number I wanted to look at was what? I thought, well, wait a minute. We have in these statistics, what was the success rate? What was the settlement rate? Did the settlement rate then drop precipitously as the sky was going to fall in? And of course, then you see from the statistics that in fact, in 18, it was 62.8%, 19, 65.8, 2020, 65.7, 2021, 64.7. The sky did not fall in. There are other interesting statistics embedded in this. Justice Lee, I'm going to do a full report. Particularly I want to take a look at the rural counties, and I want to take a look at this court by court as we get into communication, et cetera. But the important point that I'm conveying here is that when we get to 2021 with a significant increase in mediations, is that the settlement rate was not affected. And so the sky didn't fall in. I found that interesting. There are other statistics, but in any event, those are the statistics. Thank you, Steph, for sending out the others. New commissioners attended an orientation session. Linda, John, and Mark. Linda, if you'll briefly introduce yourself. Yes, Lori, did you have a point? Were you? You're on mute, Lori. You're on mute, Lori. Lori, those are my famous words, by the way, that I always get to say to everybody. You're on mute. Let's come back to you, Lori, okay, as you're figuring that out. Linda, John, and Mark, why don't you go ahead and give us a brief introduction, okay?
Should I start?
You can start. Yes, ma'am.
Hello, everybody. My name is Linda Warren Seeley. I currently serve as pro bono counsel for the law firm of Butler Snow. I am also the chair of the board for the Mid-South Community Justice and Mediation Center here in Memphis. I've been a mediator since about 2002 with a specialty in family law and I also am not certified. What's the word? I also can domestic violence trainings and mediations. Thank you. I recently living in the Washington, D.C. area, working for the American Bar Association as the director of the section of the dispute resolution. And I really appreciate the Tennessee Supreme Court for appointing me to this particular commission. And I get to keep my hand in the field of ADR. So thank you.
Yeah, thank you. Yeah, John, can you introduce yourself?
Sure. John Tarpley. I am a lawyer at Lewis Thomason in Nashville, and I know that I look as young and as attractive as Deborah Taylor Tate, but I'm here to tell you that we are very close in age to one another, and that we actually went to high school, and we were both in high school for the last year of Murfreesboro Central, which was the largest high school in the state, the year of the tiger, right, Debbie? And so we have known each other for a long time. We both went to UT. We've had a similar friend network. We've crossed paths throughout the years. So I'm glad to be here. I am a Rule 31 listed mediator. I've been doing that for several years. I've just finished my 1,000th mediation, and I'm trudging forward. So I'm so grateful to be here. Had a long acquaintance with my friend Linda Seeley. We both served on the board of the TBA together, and then my friend Mark Harwell. Holy moly, we were both on the board of Alpha International and have been friends for a long time. So I'm glad to be here. So thank you.
Great. Thank you, John. Yeah, Mark.
Yes, I too am glad to be here, and I appreciate you, Justice Lee, and the rest of the justices of the Supreme Court for giving me what I consider to be an honor to work with this esteemed panel in such an important area of dispute resolution for our state. I am the founding member of the Harwell Law Group in Chattanooga, Tennessee. I founded this firm 3 years ago after leaving a relatively large firm that I enjoyed for a period of about 30 years following my graduation from UT Law back in 1989. Seems so long ago. I'm a senior director of the Federation of Defense and Corporate Counsel, which is a organization that focuses upon the defense of of corporations and insurance carriers. And I am also honored to be approved by the Tennessee Trial Lawyers Association as a trusted neutral in mediation. So I wear that hat very proudly, and glad to be a part of this, and glad to be with y'all today.
Yeah, thank you, Mark. Thank all of you for your, accepting that position. And so, I have to say something to Justice Lee again. When Justice Lee called me, I responded when she asked me to become the director. I responded with words such as privilege, it's an honor. And after reading Rule 31, I did realize that the word that I should have used, that's a word that actually is used throughout Rule 31, is responsible. That we are responsible then, and I take that responsibility seriously. And so obviously, as the returning commissioners here, we take that responsibility along with the staff. And all of you know that if you take a look at Rule 31, Section 16, it sets forth primarily the core responsibilities. And as we go through these committee meetings, a lot of them are administrative, but there is one in particular, paragraph number 12, that says taking such other steps by reasonably necessary to establish, maintain, and improve the ADR programs in Tennessee. And so as a result, then we're also going to be talking, and we've already started having those conversations in committees about some of those ideas. But in any event, I think that obviously I appreciate, and we all take then the fact that we're responsible for the administration of this, and we're responsible not just to the court and not just to the parties, but ultimately to the public. And so, Justice Lee, I know that you have a commission that will take that responsibility very seriously. Okay, let's turn to the AOC staff report.
All right. Good morning, everyone. I'm Ann Louise Worthland, and I'm an assistant director and the director of access to justice for the AOC. I'm going to touch on your agenda items A and C, and then I'm going to turn it over to John Jefferson to provide the medical debt ODR pilot update. As you all know, John was the programs manager for this commission, and now is our first ever chief of staff at the AOC. But he is steering the ship for the medical debt ODR pilot still, and making sure that that project, that pilot project, pushes forward. So as of right now, as of January 10th, we have for renewals, 895 out of 1,354 mediators have renewed. So that's about 66%. Steph and others have done a great job of continuing to remind people. We, I don't say struggle, that's not the right word. Every year, regardless of the number of communications and methods of communications we send out, we always get people who state that they did not know they needed to renew. So any suggestions that our new members and specifically communications may have to help us just get the word out to Rule 31 mediators in various methods to make sure that one, they renew by the December 31st, so they don't have to pay an increased fee, is wonderful. And then also, as you all know, as we get later into the quarter, there are other ramifications that happen if you don't renew. So any suggestions that this group can give us as to different modes of communicating the renewal requirements, we greatly appreciate. We love the mediator portal. It's amazing what we can do on our end in terms of answering questions and approving CME courses and things of that nature. It really, really, really has increased the efficiency of the renewal process since our IT department put that into place, and since John and Steph and I can really get in there at any time of day and be processing renewals. One thing that is exciting that Steph has kept on our radar, and we actually have a meeting next week, is we're talking with our IT department about how people could pay for their renewal a little bit differently. So it's sort of all in one platform, and people not having to go to two different systems to pay via credit card. So we're really excited to have that meeting in the books. because we think just anything we can do to make the process easier on our Rule 31 mediators, but also on our staff and the commission and those that are reviewing these, we are game for. You may remember that, as late as 2018, 17, 18, we were doing renewals were all paper. So we have come leaps and bounds, and we're excited to continue to improve and expand that process. And thank you, John. John is showing you just what that looks like if you're not familiar with the portal, but we love the portal. It's a wonderful tool for this program. So I'm going to skip forward to item C.
Hey, Louise, can I
Yes,
ask you,
sure.
let me ask you a question?
Yeah.
When you say some people say that they didn't get it or whatever, is this simply one or two people, or do we have a systemic problem? Have you diagnosed? I don't know what we're doing now, how often we send them out. Is this just a one-off, or is there something systemic, do you think?
I don't want to say systemic, Steve. I want to say it's probably more than one or two. But I don't want to say systemic. But I think it's just, people are inundated with communication via email and other things of that nature. And I think people are not, if they don't have it on their radar that this is an annual requirement, then they may open it and say, oh, I'll do that next week, or they may just delete the email thinking it's a different type of communication, regardless of what the subject line and other things may say. So just with any other administrative procedure, you have folks who neglect to make that an annual reminder.
I'm
We
curious
send out
about one other thing.
4 or 5 reminders, many reminders.
Many reminders.
Many.
Is that I get reminders from the Board of Professional Responsibility about my law license and about that. I mean, I don't know to what extent that we're similar to their methodology of their approach of contacting.
Email. I mean, we've been using email. We've improved our email, I think, to using a system called MailChimp, where it lets you put pictures and links and different things. So it's not just sort of a standard email with typing that would come from someone else. We're able to personalize, so it's to them, to their name. We're able to do a whole lot of things. So, I mean, it looks like a very professional type communication. But I just think that for people who, again, this isn't on their radar, maybe they don't have another professional license, I'm not sure, but they are, will claim that they haven't received emails or they didn't receive it. And that's whatever. We don't go into whether or not they did or didn't receive emails. We can track and check in MailChimp if things were bounced back, if people opened it. So, we can monitor things like that. And we do. But again, if there's any, if the communications committee in particular or others just have suggestions on how we can incorporate other modes of communication into renewals, we're happy to try it.
Okay. Thank you, Ann Louise. Yeah. What's your next topic?
I just wanted, we kept item C, the TBA petition to adopt the Tennessee Supreme Court Rule 31B. And that's number 5 in your materials. We just wanted to update the commission since the last time the commission met, which was in October, that that petition, again, submitted by the TBA, in which it requested the court adopt a new Supreme Court rule addressing domestic relations arbitration and amend Supreme Court Rule 31A to eliminate non-binding arbitration from that rule, was denied. John is pulling that petition, the order up on the screen. That is just an update we wanted to provide. We know that some in the mediation community may be involved in different ways in that project of the TBA or initiative of the TBA. And so we just wanted to provide that update for the commission, since it was something that occurred since our last meeting.
Okay. All right.
And then I wanted to turn it over to John so he can provide, John Jefferson, so he can provide the update on the medical debt ODR pilot project. Take it away, John.
Thank you, Annalise. I certainly don't want to cover folks in stats, so I'll cover conceptually what we're doing, and then I'll also give you the stats as backup later. Essentially, we've been working on the Tennessee Medical Debt Project for close to 2 years. We found funding through the State Justice Institute. You should be seeing the Tennessee Med update. Let me know if you're not. And then we've been working on it. We went live with 3 different rounds of invites to debtors of or patients, those who received care from Erlanger Baroness Hospital in Chattanooga, Tennessee. And after those 3 rounds in 2021 of invites, we have a preliminary engagement rate of 26%, above 25%. We're sure it may get better than that when the dust all settles. So these were stats before the holiday. We're working on a final report to the State Justice Institute by the end of this month, and we'll be sure to share that with you as well for phase 1. We expended all the funds awarded in phase 1, and then phase 2, the steering committee is going to look at expanding to other providers in Chattanooga, possibly, or possibly expanding to other cities across the state. It's quite vague, I know, but it's because the steering committee is still discussing that and talking with all the different stakeholders, legal aid, mediators. Steve Shield is on that committee representing this commission, and then of course Judge McVeigh. I'll pause there for any questions. That's really all I have to report. We're glad to move from phase 1, proving the pilot, proving the concept, and getting engagement, and then expanding it in 2022.
Well, John, while folks are thinking about questions, let me make 2 comments. Is that one, I've handled a number of these mediations. I did not realize that I was going to move from talking to writing. And what we do now is we write, we're in chat, we're texting back and forth. The question that I asked Erlanger was this. I said, Erlanger picked out the 200 plus most difficult people they've had time connecting with. These folks have ignored in person, they ignored responses, they ignored phone calls, they've ignored letters. And so as a result, then it was this group, if you're wondering about that number, that were sent an email that said, would you like to engage on this online platform? And what I understand, John, you correct me if wrong, Erlanger was not expecting much of a response. And so my question to Erlanger was this: do you think the fact that this was an online platform with the opportunity to engage a mediator had any influence of those individuals deciding to engage you? And John, you remember what the answer was, don't you? Yes. Yes. They thought that this online platform, along with the opportunity to engage a mediator, actually had some influence over individuals who had literally ignored any and every communication in the past. And I found that to be kind of interesting. Now, the next round, I understand, are individuals who have not been, have been found not to be quite as uncommunicative as these particular individuals. And so, and John Jefferson, you have done an incredible job of working with the steering committee, et cetera. And thanks goes to you. And as we go forward, I know you're going to be centrally involved in this. What's next? Then committee reports. Anybody got questions about the med debt? By the way, one last thing. The eyes of the nation are on this. John, as I understand it, we've had a number of inquiries from communities across the country asking about med debt, because remember, this is pre-suit. This, in fact, allows an individual to avoid a judgment, because what occurs is this: if you don't pay, you're either sued in court or you're turned over to a collection agency. And so as a result, this is giving a number of people an opportunity pre-suit to resolve their debt. Or let me mention one other thing that's important. Sometimes we as the mediator provide missing information. For some reason, they've missed the fact that they may be available, there may be financial aid available, or actually payments to be made. And as a result, then we as the mediators have helped them to get this missing piece of information, at least at this particular point. And so far from the mediator standpoint, Other than the fact that I've got to learn how to type as opposed to talking. And so we're texting. And I think maybe that may be the way of the world. Who knows? Okay. Let's go on to committee reports. Lori, have you got your, are you unmuted, Lori?
I
There we go.
am.
Thank you, Lori.
Good morning. Can you hear me?
Can.
Okay. Welcome to the new members. And I will just go ahead and get started. I'm the chair of the Credentials Committee. We review the applications and discuss, if necessary, any questions that come up. The staff does a great job of helping us go through these and pointing out issues with the, as you know, each application has numerous documents associated with it. So there were 51 new applications on the batch list. Hopefully you had that in your attachment. 45 of them are recommended for approval without dispute, without discussions. And 6 were discussed at our Credentials Committee meeting. And so today, what I would like to do is, and Stephanie, if you'll help me here with the number of the, I believe it's 45 of the batch applications, I would like to move that they be approved for listing as Rule 31 mediators. And do we have a second?
Second.
Okay. All those in favor of approving the 45 applications that have been reviewed and have no issues, all those in favor say aye, please.
Aye.
Aye.
Anyone in opposition of this, make your, tell us if you have any objections. Okay, hearing none, we will, that motion passes. The next issue would have to do with some specific applicants. Specifically, we're going to call this one number 159885, folder 7. This applicant is applying for general civil, law license in 79. It's in good standing, but there were 2 complaints, 2005 and 2018. The first was a diversion, and the second was a private informal admonition. The applicant provided a brief explanation, and our committee uses the term unsuitability as the standard, and that's what the ADRC language is. So we are recommending approval on this applicant. I move that we approve.
Second.
All those in favor of approving this applicant,
Aye.
say aye.
Aye. Aye.
Anyone opposed? Hearing none, that motion for number 7, applicant, the folder number 7 passes. The next one is applicant 159885. The folder is number 7. And let me just make a comment real quickly here, especially for people who haven't been on the commission before. I don't want to make it sound like these are just, we're just flying through these and they're not, being discussed or concerned, or we're just there has been a lot of work that has gone behind each of these. So anybody who has any questions, now's the time to ask, and maybe, just understand what we're doing. But for economics of time, I know everyone's really busy. I would like to just move forward unless you do have a question. So applicant 159885, we recommend approval. Do I hear a motion?
Motion to
So
approve.
moved.
Okay, a second?
Second.
All those in favor say aye.
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 Anyone opposed?
Aye.
Did someone say they is someone opposed? I heard something. Okay, motion passes. Let's move on to applicant 159892, folder number 8. This applicant was approved for family in 2018, is applying for general civil to become dual. The law license was in 2003 in Tennessee and Virginia. It's active and in good standing, but the disciplinary history reports for both jurisdictions revealed a complaint in 2006, resulting in a suspension. The applicant gave an explanation of this, explanation on the application, and the disciplinary history was previously reviewed for family listing. This is someone that it is a suspension. They provided a very good, what we found, explanation, and we recommend approval. I move that we approve this applicant. Is there a second? All those in favor, say aye.
Aye.
Anyone opposed?
Aye.
Ms. Seeley, do you have any discussion, or did you have a question?
Linda Seeley, was that in favor of the motion or against it?
If I may, I suspect there's a lag, and so she said
Yeah.
aye for in
That's what I
favor.
think too. Yeah, yeah.
I thought that might have been what happened. Okay.
Yes, because it happened
All right,
twice.
thank you. Anyone opposed? Hearing none, that motion passes. Moving on to applicant 160345, folder attached number 9. This applicant is applying for family. The highest degree this person earned is a bachelor's. The applicant's roles listed in the work history and on the resume qualify for general civil, but are insufficient for section 14B, which require 10 years of full-time work experience in specified categories. The applicant can either take the 16-hour crossover training or provide a revised or better resume after earning a master's degree this spring. So what the committee's recommendation on this applicant is deferral, so that if he or she completes the requirements, they can ask for us to look at it again. And if they meet the requirements, then we would bring this to the commission again. So I move that we defer this applicant.
Second.
Is there a second? Thank you. All those in favor of deferring this applicant, say aye.
Aye.
Anyone opposed? Okay.
Lori Reed, this is Steve Shields. I need to ask a question. I'm not opposed to the deferral. Is this the individual though? Because this raises an issue that's come up before this commission before. Is this individual then work history such that she would not qualify for the family listing?
That's correct.
So what you're telling me is that her work history, it doesn't matter what else she takes, she signed up for the family law listing training, but her resume, as I recall, clearly showed she did not meet the requirements of the list for family law. Have I got it correct, Lori Reed?
Yes, but it appears that she is in a program that if she completes it, then she may be able to qualify based on her work experience.
I see. Okay. Well, if you remember,
The
Commissioner,
bachelor, as you know, the bachelor's degree requires one type of work history, and the master's degree requires a different
I
work
got you.
history. So
Okay.
that's what we're differentiating.
Yeah. The point I'm making is several years ago, if you remember, trainers were accepting people that clearly could not be qualified for, the listing. And as a result, then I'm going to be asking the Training Education Committee to come up with some form or something in which trainers put something out or simply do some auditing to make sure that somebody doesn't pay their money who clearly on the face of their resume is not qualified. And look, I understand things slip through the cracks. I get that. But I think that, again, this is one of our obligations to help the trainers then make sure people understand, wait a minute, you don't qualify. Don't pay your money because you don't qualify right now under any set of circumstances. And so I'm going to be talking to the Training and Education Committee about that. Thank you, Lori Reed. Go on.
Sure. Okay, so the next applicant is 160224. The folder is number 10. This applicant is applying for family listing. The person is the director of probation, and that's the only full-time role under work history. The staff followed up with this person, and he or she provided a letter and a resume for support, and that was very helpful with us being able to satisfy Section 14B law as the work history, and we're recommending approval. I make a motion that we approve this 160224 applicant.
Second.
Is there a second? Thank you. All those in favor of approving this applicant, say aye. Anyone
Aye.
opposed?
Aye.
Anyone opposed? I guess there is a delay here. Okay, the motion passes and that applicant will be approved. Moving on, applicant 159870, folder number 11, is applying for general civil. Law license issued in 1979. It's active in good standing, but the disciplinary history revealed 12 complaints between 87 and 2011. All were dismissed by investigations except for one in 2001, resulting in a suspension. This applicant provided an explanation letter and supporting documentation. The committee does not believe the unsuitability standard is met and recommends approval. Again, I can tell you that we read the explanations that people provide, and we take those as very important. And whether it's meets the unsuitability, and obviously in this case, the suspension was in 2001. The person has been practicing since then with no issues. I recommend, or the committee recommends approval, and I move that we approve this applicant.
Second.
Is there a second? Thank you. All those in favor of approving applicant 159870, please say aye.
Aye.
And anyone opposed? That motion passes. The final applicant is 159917. It's attached in folder number 12 to your email. This applicant is applying for general civil. The applicant voluntarily provided a statement revealing 9 complaints that were filed during a 15-year tenure as a federal judge. The applicant claimed that all were dismissed, and the U.S. Court of Appeals for the Sixth Circuit confirmed that. I will add there that they were not even investigated. They were just dismissed without investigation. We are recommending approval, and I move that we approve this applicant to be listed as a Rule 31 mediator. Do I have a second?
Second.
All those in favor of approving this applicant, say aye.
Aye.
Is anyone opposed? Thank you. Motion passes.
Before we move, I'm sorry, is there anything else, Lori Reed, from your committee?
No, thank you.
Okay, before we move on, I need to make one comment about and echo something that Lori Reed was saying is that particularly we have other viewers of this particular matter. I know you were sort of summarizing all of this. I, for the first time, sat in on that committee. You guys did an incredible amount of work, read every piece of paper, discussed every piece of paper, went back and forth and had a very good discussion about each one of these individuals. And so this was not some perfunctory review of these individuals. It was very in-depth, and I appreciate the work that you and your committee did, Lori. Thank you. Let's go into the Training Education Committee. Marcus?
Thank you, Mr. Chair. Good morning, everybody. My name is Marcus Rudolph. I'm the chair of the Training and Education Committee. It's an honor to be in front of you guys again. I would like to thank the AOC and all of its staff for all of its hard work and diligence for assisting all the committees. It's very appreciated. And I also like to thank my colleagues, Ms. Linda Silly and Mr. Charles Hill, for all their diligence and hard work. You're fantastic humans. I really appreciate it. My report is twofold. We'll go over expeditiously over the training waiver requests that our committee received, and also give a quick update on domestic violence training with my colleague and friend, Mr. Chuck Hill. So let's get started. We have 6 waiver requests today. The first one is 156971, which is folder 13 for my colleagues who are following along. Applicant took a non-pre-approved course for general civil listing online and was previously deferred until questions were answered. Upon further review of the responses and additional documentation received as well, staff and checklists, the committee now recommends approval based on substantial equivalence. And I'll go over the key texts below, but this applicant, our committee looked at last quarter, and as that paragraph said, we did not have enough substantial information to make a logical decision whether to approve or disapprove. So I do appreciate the staff to keep communication with this applicant so we can get all the pertinent information, and therefore we could render a just decision. Looking at the key text real quickly, it just states train mediators who comply with qualifications set forth for Rule 31 mediators in general civil or family cases, as may be determined by the ADRC, with the assistance of the AOC programs managers, provide their training to be substantial equivalent of the required under this rule, and that the training has been completed within 6 years prior to application. So that we looked at the information, everything was confirmed, and we felt comfortable making a recommendation for approval. So on behalf of the T&E committee, I would make a motion for approval for 156971 for general civil listing. Do I have a second?
I second.
Thank you, Mr. Hill. All folks in favor for the approval of 156971, please say aye.
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 Anyone that disapproves? Thank you. Motion passes. Second applicant, applicant 160352. That's the folder 14 for my colleagues following. Applicant is applying for general civil and is approved, active, and is in good standing as a mediator in Oregon, confirmed by the state authority. Committee recommends approval based on reciprocity. This person was trained approved and did all the previous mediation up in the state of Oregon before subsequently this person moved to the state of Tennessee. So it's asking this committee to look at the previous training and all the information provided and to be approved through reciprocity. We looked at the information. This person came highly recommended from the state board. So we had no problems making the recommendation for approval. So I make the motion on behalf of the committee to approve applicant 160352. Do I have a second for motion?
Second.
All parties approve of applicant 160352 for general civil listing. Please say aye.
Aye.
Any opposed? Thank you. Motion passes. All right. Moving forward, the third applicant, applicant 159860. This is folder number 15. Applicant is applying for family and domestic violence, but the waiver that was submitted to our committee was only for domestic violence designation. Applicant provided a training list and resume to the AOC and subsequently to our committee. Our committee recommends approval for this applicant based on substantial equivalence. If you can read the first part of that key text there, to obtain a designation as specially trained in domestic violence issues, the listed Rule 31 family mediator must have completed a 12-hour course on domestic violence issues approved by the procedures outlined in subsection F and shall provide to the ADRC proof of attendance at the approved course. I do believe this applicant had more designated hours than 12. So giving that all that information, our committee feels comfortable making a recommendation for approval. So I'll make the motion to approve applicant 159860 for domestic violence designation. Do I have a second?
Second.
All folks in favor of 159860 to be approved, please say aye.
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 All opposed? Thank you. Motion passes. Fourth applicant, applicant 159904. This is folder 16 for my colleagues. Applicant is applying for general civil listing. The applicant completed a mediation course, which awards at least 3 semester hours credit within 6 years. The transcript provided by the applicant shows curriculum components comparable to the rule. The committee recommends approval based on substantial equivalence. And again, the key text just states in regards to what this person provided, holding a graduate degree and providing all the subsequent information that we were looking for. So we were comfortable of making a recommendation of approval. So I make a motion on behalf of the T&E committee to approve applicant 159904 for general civil listing. Do I have a second?
Second.
Second.
All parties in favor of 159904 being approved for general civil listing, please say aye.
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 Opposed? Motion passes. Fifth applicant, applicant 160279, and this is folder 17. The applicant is applying for general civil listing. The applicant taught a mediation course of 2 hours for 4 semesters at an accredited law school, totaling 8 hours of instruction. This exceeds the standard set in the rule. So the committee feels very comfortable with making a recommendation to approve this applicant over the basis of substantial equivalence. So on behalf of the Training and Education Committee, I make a motion for applicant 160279 be approved for general civil listing. Do I have a second?
Second.
All parties in favor of applicant 160279 to be approved for general civil listing, please say aye.
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 All parties opposed?
Aye.
All parties opposed? All right, motion passed. And our last applicant, applicant 159865. This is folder 18 for my colleagues. Applicant's family application was approved in October 2021, but the domestic violence designation training waiver was deferred until information was obtained. This is similar to our first applicant. We did not have enough information to properly make it an approval or disapproval. And again, credit to the AOC staff for keeping on this applicant until we got all the designated information that we needed to make and render a decision. So we feel comfortable in regards to making a recommendation of approval for this applicant based on substantial equivalency. So I make a motion for applicant 159865 to be approved for a domestic violence designation. Do I get a second?
Second.
Thank you. All parties in favor of applicant 159865 be approved for domestic violence designation, please say aye.
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 All parties opposed? Thank you. Motion passes. Thank you. Just wanted to give a quick update, and Mr. Hill, if you would like to chime in when I'm done. The committee is currently brainstorming a revision to the curriculum required for the 12-hour domestic violence training. Mr. Hill, can you expand a little bit more on why we're trying to do this?
Sure. This is an issue that came about when I completed the domestic violence training back in 2005, and I was given a lot of information about the demographics, how prevalent domestic violence is, that it can affect both men and women, and so forth and so on. But I was disappointed that it didn't cover, as a mediator, what do you need to do differently when you're working with people who have had domestic violence as part of their history. So we're not talking about mediating domestic violence cases. We're talking about mediating cases where there has been domestic violence. And if we say that a person has specially trained in domestic violence issues, I think the public is entitled to assume that a mediator with that training has had some skills, some experience, some training in what you might do differently in those cases than in other cases that you mediate. And so trying to look at that content and determine, can we update it so that mediators have more skills in dealing with those kinds of cases is really the focus of this initiative.
Thank you, Mr. Hill. And our committee will make sure that we keep the commission apprised of anything that we come about moving forward in the future. That concludes my report. I would like to say one more thing. I wish our colleague and our friend, Ms. Stephanie Brake, good luck. She's going to be taking her bar exam pretty soon. I know she will kick butt and take names. So we will cheering you on, and please make sure that you let us know how everything goes about. But
no pressure on her, Marcus. No
Thank you,
pressure.
Mr. Chair.
No pressure. So, let me just comment.
Yes,
let me reflect back. I want everyone to understand that as we go through these fairly quickly, this committee spent a great deal of time looking through all of the documentation that was presented to it. This was not a cursory review at all. It was looked at very, very carefully. I think Chuck has made a really important point. You know, mediation is an action sport. The fact of the matter is that it's got content knowledge, but it's got skills. Once we learn those skills, we have to strategically figure out how to use those skills at what particular point and in what context. And so I'm looking forward to the committee looking at that and several other matters as we move forward. I think it's a great comment, Chuck Hill. I appreciate it very much. And so, and I appreciate the committee, Marcus, and all the work that you've done. Okay, Sarah, let's turn to you.
The Pro Bono Mediation and Advisory Joint Committee has nothing to submit for discussion at the moment. We did meet together and we are reviewing specifically two things. One is involves just generally potential barriers to kind of the effective functioning of the community mediation centers. We're trying to find out if there's anything the ADRC can do to ensure that they can maximize their impact. We are also discussing an issue that has existed now for some time, inconsistently across courts, about how the degree to which mediators, and particularly pro bono mediators out of the CMCs, can file settlement agreements. So if any of you feel very strongly about these, you're welcome to join us. Send me an email, but we expect to provide some sort of, well, at least materials for discussion for our next meeting.
And thank you, Sarah. The fact is that I think obviously we know where most of the pro bono mediations take place. They are in fact then volunteers at the community mediation centers. And so the question is, this commission has done a number of things over the last several years to assist and to help them be more effective and to provide some assistance. Obviously now, what Sarah and her committee are looking at is, are there any roadblocks that could be removed, if any, that would help them to have a more impact and to operate more efficiently, as well as the issue that came up in the advisory committee. Remember, we have an advisory ethics committee that says you can't file that settlement agreement, et cetera. And that has reared its head again in terms of how do we deal with that. And so I'm looking forward to that discussion and probably some other items. And so thank you, Sarah. I know your committee spent a good deal of time analyzing and thinking through then what are the potential barriers, the potential roadblocks that could help us make our CMCs more effective. Okay, thank you, Sarah. All right, let me, grievance committee, Marcus, it's back to you.
Thank you, Mr. Chair. The grievance committee had just one filed complaint that we oversaw and reviewed. The mediator in question, after we made a ruling, completed the required CME, and all parties have been notified in regards to the situation, and the matter is closed. So I just want to tell Dr. Fiegel, Ms. Edenhoff, and also to Mr. Ladd, thank you for all of your assistance and support in regards to taking care of this matter.
Okay, good work, committee, good work. Cindy, Communications Committee.
Well, thank you, Mr. Chair. I have the easiest report today, and that is because in part, Ann Louise has already put forth our real issue. What the Communication Committee primarily does is they are involved in the notifications to mediators about the renewal date. And we currently there's provided 4 reminders prior to the December 31st deadline. And those reminders are in late October, late November, and then 2 reminders in December, the last of which is about 10 days before the December 31st deadline. So Ann Louise had mentioned earlier, and what I would also ask is that if any of you have any suggestions that might bring the renewal date to the mind of those who need to know it, any means of making sure, because we have all seen mediators who miss their deadline, good mediators who had been practicing for a long period of time, who missed their deadline to renew and went, oh my gosh, and then had to go back and retake training in order to get their mediator listing in Tennessee. So if anyone has any ideas at all about a way to maybe make that a more visible or more noticeable kind of reminder to mediators to be sure and register in time and pay in time, I'd certainly welcome them. And that's it for us. Thank you all.
Well, Cindy, let me go back and mention a couple of things that you and I actually talked about, was working with Justice Lee and talking about communicating the Tennessee Supreme Court plan to the judges across the state, how that communication process might work. We'll be having that conversation. You also mentioned about the quarterly newsletter. And I know that we've had the commissioners write about the basic principles, but and I've asked the staff to provide me with some of those articles that we used to write.
That's true. Our committee is meeting next week to discuss that. I just didn't want to go forward without having spoken with them fully.
Yeah, what's the idea? It's the idea. And my idea right now is this, and I know we'll talk about in the committee, is that the sky didn't fall in. I think these statistics clearly prove that the sky, everybody said you can't do it by Zoom. The settlement agreements are going to go, by the wayside. And so I think that one of the things and I'll volunteer at some point, is to actually put together some of these statistics for, everybody's review and to provide it in part of the newsletter. And so in any event, and there's going to be several other ideas that the communication committee is going to be discussing. And so thank you, Cindy. I know that you're getting ready to meet. And so Gail.
Yes, I just wanted to chime in here, Cindy, about your request for any ideas about how to get the word out. I'll just share my personal experience. It used to be a real chore to do that every year. I had to gather data, get files, get paper together. And I think this is just the second year we could do it online. It is so easy. And I mean, they already tell you how many reports you file that are federal court, state court. I mean, if we could just get the word out about how quick and easy it is, like the easy button that you push that says easy, I think we'd have a lot higher response.
I love it. Thank you. I love it.
Easy. So I don't know how you leverage that, but particularly at the annual CLE that the ADRC does, if someone could demo that or do a YouTube demo, I mean, it took 5 minutes or less. And it used to take me an hour or more. So that's my testimonial on that issue.
I want to see the easy button in your up on your wall then the next time.
We have one, but it's in the file room where we copy.
I got you, Gail. And so in your outline are the renewal efforts, the reminders of the initial deadlines. And so if anybody calls and has a question, and those deadlines are set in there, is that right, Anne Louise?
Yes.
Okay, and
It
John.
is right.
Okay. Richard, the Ethics Advisory Committee, it sounds, let me turn it to you.
Sure. Before I start, Steph, I have some bar exam advice for you. I had to take both the Tennessee and the Virginia bar. And so I'm going to apply some advice I got regarding the Virginia bar to you taking the Tennessee bar. It was 2 or 3 days before the bar exam, and I was feeling slightly nervous. And only slightly. I went into one of the partners that I respect greatly and asked him a question about a concept of Virginia law. And he very quietly walked over to his bookshelf and grabbed a book and said, "The answers to many of your questions are found in these green books." So that's my advice for you. I think if you memorize the code, you'll be well on your way. And best of luck to you.
Thank you, sir. I appreciate that.
All right, Ethics Advisory Committee. We have one pending request before us. It involves some post-mediation session actions taken by the mediator and counsel involved in that case. We have already met once to go over that. We've narrowed down the issues that we believe as a committee fall within the scope of Rule 31. There were a couple of them that were really Tennessee Board of Professional Responsibility questions more than mediation questions. There was a request for additional information. We now have that information, and we are going to have a second meeting in the immediate future. And at that time, I think we'll be ready to draft our opinion. And Steph, thank you so much for all your help as well.
Okay, thank you, Richard. I appreciate it very much. Elizabeth is not here for the Rule and Policy Review Committee, but there are no new updates. And so as a result, and that takes us to the closing remarks, of which I guess overall, all I can say is, it is such a real privilege to work with this commission, to work with a group of people that have shared values. And not only that, have democracy in action. The civil discussions that occur in each one of these committee meetings is just exemplary. And so I can't tell you how much I've appreciated the work that's been done. I look forward to being the chair, and all the hard work I know is going to be done in the committee meetings. And as a result, I look forward to working with each one of the committees. And as always, Justice Lee, thank you for your leadership, and in particular regarding the Tennessee Supreme Court ADR plan. And it obviously is going to be our lights as we go forward. And we appreciate everything you've done. Ann Louise, do you want to go over, or John, do you want to go over any other details? I see some final details here, the rule application next quarterly meeting. Do you want to share that with us before we adjourn?
Sure. As Steve said, the next quarterly meeting is going to be on Tuesday, April 19th at 10:30 Central. We hope that and expect to be able to offer an in-person participation option at the AOC. So just look for that opportunity. The application deadline corresponding with that meeting is going to be on Tuesday, March 1st. So that will be when, staff will begin compiling everything for everybody, and our committees will gear up for meeting. And so just, I think you all kind of know the schedule, the routine. We tend to meet about a week to 2 weeks prior to the commission meeting, once staff has had an opportunity to review all those applications and everything. And then, John, did you have anything on your end you wanted to include, or staff, in an update before we close out?
I'm good. Thank you.
I'm good as well. Thank you, everyone.
And I also would like to reiterate to Steph, good luck. We know you're going to do great on the
You'll
board.
do great, Steph. We
Thank you,
appreciate it.
Captain.
Yeah. And so is there any other business before the commission? Okay.
Just a quick acknowledgement and congratulations to John Jefferson on his not so recent but still new promotion.
Yes. Congratulations, John.
Can we start every meeting with "Hail to the Chief"?
Well, he will send the song out to you shortly. So thank you, everyone. I appreciate it. There'll be no further business before the commission. A motion to adjourn.
So moved.
I moved.
All in favor?
Aye.
Any
Aye.